me.
Yes, Ms. Gray.
May it please the court, together with Mr. Varden, we represent the appellant, Nardis Maynard. The respondent is represented by Miss Weeks, KC, and Mr. Pater.
Before you go on, I think there's been a misprint in the timetable, or there may have been a misprint in the timetable, because as it currently appears, the respondent's only getting half an hour before lunch and half an hour after lunch, i.e. 1 hour.
Yeah, we're a bit worried about that, my
Well, unless you'd said you only wanted an hour, it seemed to me you ought to have until 3:30 and then 3:30 to 4 for reply.
Thank you.
It doesn't shorten your slot at all, but it just seemed a bit odd, and I think it must be a misprint.
Thank you. I may be quicker, I don't know.
Well, you don't have to take your allotted time, but of course that doesn't increase the allocation of your opponent. Yes.
Before moving to the substance of the appeal, there is an application in relation to a supplementary bundle,
Yes.
which was provided to the court on Monday.
We've got it, as it were, di bene esse.
I'm grateful. The position, my lord, is simply this, is that as a duty of candour, our obligation to the court, it's to correct the position, as your lordships, my ladies, will have seen in the skeleton arguments, reference to the appellant, as it was believed, was 5'1".
Yeah.
But we have had that position confirmed, and the court will have noticed from the Court of Appeal's judgment, at, just for reference, at page 266 and it's paragraph 65, that the Court of Appeal had said critically there's no material which confirms that Maynard is in fact 5'1". Now we sought to get that confirmed and correct the position, and as the court will see from Taliba Byron, and I must apologise, Taliba Byron is also assisting us with this appeal, and I failed to mention her name at the outset, that the statement from Taliba Byron, who attended the prison, and the appellant was measured by Sergeant Gums, and the court will see that he's just over 5'6".
Yes. Well, is the admission of this corrected material opposed?
Yes, my
It is opposed.
It is.
Right.
We haven't agreed it.
I'll hear your position in a moment.
The appellant was measured, and as we'll see from the officer of the court, Taliba Byron was present when the appellant was measured by a prison officer. It's effectively a declaration against the appellant's own interest. This weakens. We still maintain the identification points, but it weakens.
Yeah.
Because, of course, initially we thought he was 5'1", but in fact he's just over 5'6". So
You're coming out to court out of a sense of duty to the court.
of course,
Yes.
and that's we'd say the right thing to do to put everybody in what is the correct picture,
Yes.
even though it goes against the appellant's case to some extent.
Yes. Well, Ms. Weeks, what do you want to say about this?
I don't know whether my lord and my ladies have read our response, which is attached to these documents. I see that one or two of you have nodded. Frankly, I don't have anything to add to those objections. Perhaps I'll give you a moment to make sure that you've got it.
Yes.
We asked that be presented to you all. The most important factor that worries us is you are all familiar with the length of time that has expired since the trial in 2004. It would be helpful to all of us if he was measured at the time of the event or sometime soon thereafter, not to be measured last week. I've no idea as to what support and credibility we can take it that his height now has anything to do with the height at the time, because that's what's
Well, the point is understood.
That's our point.
Thank you very much.
But all this is in a sense against your case.
Sorry?
The height is against your case.
It depends which height it is. 5'1" was correctly.
Sorry, I mean it's evidence that's of favour for you.
It can be. I can see that point. The purity of it is, there's no point measuring the man now without there being both sides to deal with that there was a proper measurement.
Right.
And the real issue was, for the identifying witnesses, what was his measurement at the time when he was age 22?
Right, but I'm just puzzled because I think the appellant has put this forward out of a sense of duty. It's entirely against their own interest to do that. But you're somehow resisting this. This is what I don't follow.
I am not against the candour that she wishes to make sure that you know what the height of the defendant is now. All we say is the relevant height is at the time of the event, not 20 years later.
Yeah.
That's the point we
Well,
make.
thank you very much. Thank you for both. Anything you want to say in reply?
No, I only say this, that the appellant was born on the 29th of September 1981. He was 21. It's unlikely that he was going to grow anymore, so nothing further.
Yes. Well, we will rule on this application together with our advice to His Majesty at the end of the hearing, rather than take up time withdrawing and giving a judgment now. I don't think, so you can deal with it de beniesi on the basis that we've already read it, and we will look at it, we'll hear any relevant submissions about the consequences,
Yes.
but rule on its admissibility at the end of the day.
Thank you.
This is an appeal against conviction in relation to a murder conviction. The appeal being heard on the 10th of June 2022, with the judgment being provided on the 10th of June 2022, in relation to the appellant's conviction on the 7th of July 2004 for murder. The conviction appeal was dismissed by the Eastern Caribbean Supreme Court, sitting in the Court of Appeal of St Christopher and Nevis. There were two aspects to that appeal. That the original murder conviction appeal, which was abandoned on the day of the appeal hearing in 2006, was a nullity, and the Court of Appeal so found in light of the respondent's concession that the abandonment was a nullity that back in 2006, and that if the court found the abandonment was a nullity, the appellant applied to reopen his appeal. And there were three substantive grounds of appeal: that the failure to call the alibi witnesses at trial, the failure in the course of the summing up to identify any specific, not just some specific, but any specific identification, weaknesses and inconsistencies, and the failure to adduce, to provide the good character direction, the two limbs of the good character direction, propensity and credibility, in light of the fact that the appellant had no previous convictions. Now, that was, of course, just dealing with, if I may just take that for a second, the character point, although it appears in the written material that would appear to be a failing by the judge, it wasn't, because it wasn't adduced by the lawyers. It wasn't adduced in evidence at the time. And so those were the three appeal points. And of course, the Court of Appeal found that there was some merit in relation to the identification issues, and that there were some, they recognised that there were some weaknesses that had been failed to be put before the jury. And of course, the failure to the Crown, of course, conceded that there was a failure to put the character direction before the jury. So, and of course, the Court of Appeal applied the proviso, recognising that there were defects, and in relation to the case of Cassell and Lord Hughes, that of course, the more defects there are, the more it may well impact on the result and the findings. So those are the issues that we seek to address the court on this morning. And if we may take them out of turn, we would like to deal with the identification issue first and foremost. And if we, that ground of appeal, the identification, is found at the electronic bundle, page 416 of our written case. And we're aware that the court is fully appraised of the factual analysis of this case, but it just for the ease of the argument, and if I can put it this way, that as we have headlined, that the judge, during the course of the summing up, made not a single reference, as we have repeatedly highlighted. It's not a case of, well, he missed out one or two weaknesses he failed to mention. We say that none of the identification weaknesses were flagged up to the jury at all. And really, this was a case where identification was at the heart. There was really no other supporting evidence, and I would say that with this caveat, that the assailant from the evidence was clearly left-handed, and the appellant was left-handed, but so too was the brother, Vincent Baldhead, who was the first person to have been, from the family, to be arrested. He too was left-handed. So that may be supporting evidence, but it's neutralised by the fact that somebody else who had been a suspect was also left-handed. But save for that, this case stands and falls on identification evidence. And just dealing with it like this, the witnesses, Marilyn Lowry, the mother, and Kamisha Powell, the daughter, who say that they gave recognition evidence that they knew Nardis Maynard. It would seem that the Court of Appeal, we'd say, fell into error in that it was assumed that there were three witnesses that knew the assailant, and that other person was Jason Hamilton. But we say that Jason Hamilton is not in the same category as Marilyn Lowry and Kamisha Powell. And we have plenty to say about those two witnesses, but just dealing with Jason Hamilton for a moment. Jason Hamilton provided a statement. He also gave evidence at deposition and gave evidence at trial. In his witness statement, he never identified Nardis Maynard. He never said, "I saw Nardis Maynard." In his witness statement, he said that he identified a man, fair-skinned, of about 5'10" tall. He said that he thought that the man was a relative of somebody called Bishop, and he would see him in the local area. When it came to his deposition in June 2003, he effectively gave a doc identification and said, well, that's him there. When he came to give his evidence at trial in July 2004, the evidence appeared as if, certainly how the notes have been taken, by calling him Nardis, as if he knew it was, the assailant was Nardis Maynard. Now, during the course of cross-examination, it was put to him, well, you never said the name in your statement. You referred to a man 5 foot 10 inches tall. And he said that he was more friendly with the brother known as Eric. So that is the extent of Jason Hamilton. He did not identify in his witness statement as, I recognise the assailant as Nardis Maynard, which can be contrasted with how Marilyn Lowry and Kamisha Powell testified and articulated the position in their witness statements. So to lump Jason Hamilton as recognition evidence in the same way as Marilyn Lowry and Kamisha Powell, we say was wholly wrong.
Can I just ask you, for a point of information, when you say it was effectively a doc identification, can you just run me through how that occurred, as you understand it?
Yes, if I may, I think I'd just like to take you to the deposition, which is just bear with me. I'm just.
Yes, I think it's electronic bundle, page 70.
Thank you very much indeed.
70.
Thank you. Thank you very much. It's the page. Yes, it begins at page 69. The deponent Jason Hamilton.
Yeah.
And then if we just move on to page 70, where he says it's the third line, the gentleman who was facing west, I recognise to be, #2, witness points to accused Nardis Maynard. Now, Nardis Maynard, of course, present during the course of the depositions, and Nardis Maynard would have been in court in the dock, and the witness, Jason Hamilton, who in his statement had not identified Nardis Maynard, but it had been limited to a man of 5 foot 10, fair skin, a relative of Bishop, and if the court wants assistance in order to contrast that with his original statement, which is at page 54 of the electronic bundle.
But Ms. Gray, before you go there, he goes on to say, I know the accused now as Screw, but now at the time I did not know his name.
Yes,
So this is the point you were making, that the name suddenly becomes important when he's giving evidence, but at the deposition stage, he accepts that he did not know the name before.
That's right. We know not how he suddenly arrived at how do you know the name? Daddy Screw is referred to in Kamisha Powell and Marilyn Lowry's witness statements and their evidence as how they know his alias, his nickname, as Daddy Screw. And yes, there's been a contrast between Jason Hamilton's witness statement, where he's didn't know his name, to now he knows his name, but we don't know how he came to know that name.
It's a small point, I think, but when you say his name, I don't think it records him as saying his name was Nardis Maynard, does it?
He doesn't say at any stage,
He just
either in
says
his...
Screw. Says
Yes.
he knows him as Screw.
Yes.
Well.
The two witnesses, Kamisha Powell and Marilyn Lowry, say that they know Nardis Maynard is Daddy Screw.
Yeah.
I think one says Screw and one says Daddy Screw. Is that?
Jason Hamilton, in his original witness statement, makes no reference to name whatsoever, just the height and that he is familiar with the... He's a relative of Bishop. Yeah?
Was there evidence that Eric is Bishop?
There wasn't. There wasn't evidence that Eric is Bishop.
And how many brothers are there?
There's 4. Terence, who died in 2012. Vincent, who was the original suspect. There was an anonymous call to the police officer, PC Sutton, shortly after the incident, where it was said from a public payphone box, go find Baldhead, Cutie's son. Baldhead, and in the evidence, Baldhead is known as Vincent. Vincent Maynard, Baldhead is his nickname. And Vincent was originally arrested. So that's 2. There's Damien, is the youngest, Damien Maynard. And there is Nardis.
So there wasn't an Eric.
No, Eric was Eric, on our instructions, Eric is a nickname for Terence, who died in 2012.
You say that the record doesn't reveal how this witness came to know that he was called Nardis, but it looks as if he would have found out when this deposition was read over to him and before he signed it on page, before he agreed its truth, as we see on page 71, by which time that bit in brackets would have been apparent to him, wouldn't it?
I recognise to be accused to witness points to Nardis. I know him now as Screw.
Yes, he's saying at that time, I know him as a Screw, but somebody has helpfully put in brackets witness points to second accused Nardis Maynard. That would have been in the deposition transcript, which he was asked to approve after he'd given his evidence.
Yes.
That's how he finds out that he's called Nardis Maynard.
That's right.
There's no mystery about it.
No, the only mystery is in relation to how does he know he's called Screw? How did he find out he was called Screw?
Okay.
That's...
I thought you made the particular point about calling him Nardis at the trial,
Yes.
when you were summarising your case on this point.
There is reference at trial to him referring to Nardis, and it looked like it may have appeared to the jury as if he would know him as Nardis. He knew him better than, in fact, he actually did, which is why he was brought back to his original witness statement. So going back to the original point is that Jason Hamilton and his identification evidence does not stand in the same way as Marilyn Lowry and Kamisha Powell. So just dealing with just taking the identification witnesses. So Marilyn Lowry, the mother, who appears to be the one who hears some argument outside. She was in her bedroom and she hears the argument and she goes to her bedroom window and she looks out and she says that she can see 2 people. And she says that she can see that there's an argument about money and Nardis Maynard asking the other for money. And then she leaves. She walks away from her window and she goes to the bathroom. She returns from the bathroom when she hears somebody in the house, and it would appear that it was the other daughter, not Kamisha Powell, but the other daughter, sister, shouting, "Fight, fight." Now, that other daughter, sister, has not provided a witness statement at any stage, despite it appearing to be she is the one to see the fight begin, certainly of the family members. And we know not why there was no statement taken from her. As a result of the daughter saying fight, fight, the mother then leaves the bathroom and goes to the veranda. So she goes outside. And she says, and throughout her evidence and her statement and her deposition, that she saw two people. And she says, certainly when it came to trial during the course of her evidence, she said that she saw this incident for 10 to 15 minutes. That's what she says, 10 to 15 minutes. And in fact, when she was outside on the veranda, she says she saw Nardis Maynard for about 2 to 3 minutes. Now, Marilyn Lowry, and the words she also hears, and again this is in contrast to Mark Handley, the police officer who'd been driving his car. She refers to boy. She hears the deceased saying sort of, boy, what are you doing? And we'll come to the significance of that in a moment. But so Marilyn Lowry has given the evidence that she's bedroom, veranda, and the timing, the length she's had the individuals under observation. Yet at no stage does Marilyn Lowry see more than two people. She said that there was no obstruction and of course we have to remember that Mark Handley referred to cars being parked on both sides of the road. But she only ever sees, despite she's saying she's watching this for 10 to 15 minutes, two people. She knows of Ingle Rawlins, the co-defendant. She knew him, but she makes no reference to seeing him. Moreover, she describes the assailant as wearing a white T-shirt and 3/4 length jeans. But despite, she says, seeing this incident for 10 to 15 minutes, she does not refer to a baby blue and white head tie that the assailant was wearing on his head. Furthermore, despite seeing this for 10 to 15 minutes, she makes no reference to seeing the stabbing or a knife. So the question, it goes to the importance of all of that is, if she was watching this for 10 to 15 minutes, she doesn't see what we say are critical factors, and must question the reliability and the accuracy of her identification. And question why, surely those matters ought to have been placed before the jury for their consideration in the context of specific weaknesses. As the case law says, and of course take the court to it, but the court will be very familiar. Turnbull, that landmark judgment, refers to the need to not just provide general directions about identification, and of course identification can lead to miscarriage of justice and those important headlines, but dealing with the specifics, not just reminding the jury, which happened in this case, regurgitating the evidence that was given by these witnesses, but to assess, to analyse, to identify in a balanced way, of course, both sides. And we say that was lacking here. And so just we've tried to draw out in very, we hope, clear terms what was missing, and that's dealing with Marilyn Lowry. We say were fundamental points that were missing from the summing up. And just dealing with Kamisha Powell, her daughter. So sorry. But Kamisha Powell became aware of what was going on because of her sister saying fighting. Kamisha Powell had been sitting in the front room, in the living room, at the dining table, when her attention was drawn to what was going on outside by her sister, who did not give evidence, and there does not appear to have been any witness statement taken from her. So Kamisha Powell goes from the dining room into her mother's bedroom and looks out of the bedroom window. Now, the importance of the words fight, fight, because both mother and daughter refer to hearing from the house the words fighting and fight, fight. So it would appear that at the same time that mother and daughter hear the word fight, fighting, fight, fight, mother goes to the veranda, and sister, who'd been sitting at the dining table, appears to go to the bedroom window, the mother's bedroom window. Kamisha Powell says that she was looking at what was going on for about 15 to 20 minutes, quote, if that long. So she sees three people, and she describes the assailant as wearing a baby blue head tie. But she identifies Ingle Rawlins, she identifies Nardis Maynard. She, in her evidence, says that Ingle Rawlins appeared to be also trying to calm the appellant down. So rather than being engaged in the incident, he was trying to disengage the appellant from what was going on. And she says, Kamisha Powell, that Ingle Rawlins, whom she knows, left before the fatal wound, left before that stabbing to the thigh, the deceased's thigh, right thigh. Now, it is important to look at Kamisha Powell's evidence together with PC Handley. PC Mark Handley was the police officer who was driving his car and who witnessed, as he was going along the road, some of it from his rearview mirror. And then he gets out of the car and he tries to follow those that he saw. But he says, and in relation to the assailant, his identification was exclusively, in his witness statement, a man in a white T-shirt. That's the extent of it in his witness statement, no more than he saw a man in a white T-shirt. It was only at the deposition stage in June that he refers to the man in the white T-shirt as being short. And that became then part of his evidence, which he also mentioned at trial. But just going back to, because it's important to look at him against Kamisha Powell. Mark Handley says that he saw, what he sees to begin with is three men braised, he uses that word braised, up against a wall. And he gives the evidence that there were two of them, and he knew Ingle Rawlins. Let me just check. And he says that he sees Ingle Rawlins and the assailant leave together. And he tries to follow them. By this stage, he's out of his car, and he tries to run after them to stop them, but he can't. So he sees them run together, which is very different to what Kamisha Powell was saying. She says that Ingle Rawlins had left and that the appellant was there. And it was after Ingle Rawlins had left that fatal wound was caused. But the importance is that Mark Handley says that he saw from the braising at the wall, which is not mentioned by Kamisha Powell. She makes no reference to seeing the three men braced against the wall. What she sees, because of course she's come into it after hearing fight, fight, looks out of her mother's bedroom window, and she sees the deceased is walking backwards up the road, and the assailant is following, and she sees the swings of the knife. She does not make any mention of the brazed wall. Mark Handley does talk of 3 people at the brazed wall, and he says he saw.
Sorry, what do you mean brazed wall?
Well, this brazed, he describes it as if brazed, that's the word he uses, 3 men huddled together at the wall.
Well, in his police statement, he said 2 of the male persons appeared as if they were blocking in another male, that is, jamming him to the wall, which I think is a pretty clear picture.
So it's not that the wall is brazed, it's they were
The 2
jammed
of
against
them
it.
were blocking, pushing him against the wall.
So thank you. His evidence is in stark contrast to Kamisha Powell, because she makes no reference to the wall at all, that part. And he says from the time he sees the 3 men at the wall to the time that the 2 men disappear, run away, is 3 to 5 minutes. That's his time estimate. And we say that Kamisha Powell must have come in at a point at which, after the incident began, and it would appear that Mark Handley has seen more of the incident than Kamisha Powell. And so one needs to be very careful of timings, because if that is the case, and this police officer is saying he's witnessed an incident and his timings are 3 to 5 minutes, and he's seeing from the wall to the time the 2 men run away, the assailant together with his associate, which is very different, much shorter. I accept it's not fleeting glance time, but it's a much shorter period of time. He's seen much more, we say, in a much shorter time than what Kamisha Powell is saying she sees in a period of 15 to 20 minutes. And those differences in times, we say, ought to have been placed before the jury, that the jury, is this really a case of people having individuals under observations for 15 to 20 minutes? Or is it much less time in circumstances where it's at night, artificial lighting, and it's, members of the jury have to ask yourself whether it was 15 or 20 minutes, or whether it was something closer to 3 to 5 minutes. We would submit a big difference, and something that was in the evidence is a clear inconsistencies in times, and the jury, we submit, ought to have been directed, flagged up, highlighted about these inconsistencies, and whether it goes to the reliability of the identification. Was it really that long, 15 to 20 minutes? The summing up, as I've said at the beginning, the summing up effectively summarises the prosecution witness's statement, evidence, and refers to Marilyn Lowry's timings, Kamisha Powell's timings of 15 to 20 minutes, but at no stage makes any reference to any inconsistencies in times that, in fact, and that analysis, that important analysis about, well, let's look at what Mark Handley saw, how much he saw, and he's saying it was 3 to 5 minutes, compared to what Kamisha Powell says she saw for 15 to 20 minutes. And the Court of Appeal, in their judgment in 2022, it's at electronic bundle page 265, paragraph 65. And it's this sentence. There's nothing which suggests that these discrepancies were explored in cross-examination to reveal whether Miss Powell and PC Handley appreciated the distinction between 15 to 20 minutes. I mean, this is the Court of Appeal, if I may just preface, that the Court of Appeal recognised, and albeit they applied the proviso, the Court of Appeal recognised that this was a defect, that the failure to highlight the inconsistencies in time was a defect. And their court said there at paragraph 65, I agree with Miss Gray's complaint that the judge in summing up should have highlighted the discrepancies between Miss Powell and PC Handley's evidence on the duration of their observation of the incident. And just moving down the page to the section, it is quite probable that Miss Powell began her observation of the incident before PC Handley did, in order to apply the proviso there. But in fact, a proper analysis of PC Handley and Kamisha Powell's evidence, and looked at with Marilyn Lowry, it can't be right that Miss Powell began her observation of the incident before PC Handley did, because she doesn't see the start and she doesn't see what's happening at the wall. Now, PC Handley had said that he said in his witness statement that he didn't see the face, he didn't really see the assailant's face. So he said he was talking about a white T-shirt, and then that was provided more detail when he gave his deposition. But the timings, he maintained at trial, or he said at trial, that it was 3 to 5 minutes. So that we submit that that's an important point, and reference it to paragraph 65 of the judgment, and that on a proper analysis, it can't be right that Miss Powell began her observations of the incident before PC Handley did. That moves on to Jason Hamilton. I referred to Jason Hamilton before. He says he sees two people. He doesn't see the stabbing. He sees two people talking. He was going into somebody else called Handley's property on that very street, and he sees Jason Hamilton, as I say, refers to somebody who was about 5'10", he says. Now, Jason Hamilton it says he didn't see Ingle Rawlins there. Now, at trial, Jason Hamilton said that he knew Ingle Rawlins for 12 years. At no stage has Jason Hamilton ever said he's known the appellant. There seemed to have been a little bit of confusion in some of the earlier skeletons being put forward by the respondent skeleton prior to the Court of Appeal hearing, that Jason Hamilton had known the appellant. That's not right. That's not what's said in the evidence, and happy to take the court to it.
Can you? Because
yes.
The judge directed the jury that he said he
Yes.
recognised Nardis Maynard.
Let me...
But it's this business of being a relative of Bishop, isn't it?
A relative of Bishop.
Back to that. That was the extent of the recognition.
That was the extent of it. And a relative of Bishop. And at trial he says, I know his brother Eric. I'm more familiar with his brother Eric. That seemed, and that was the extent of it. Let me just provide the court with the Jason Hamilton's.
When he first mentioned recognition of relative of Bishop, he didn't say brother of Bishop, but relative.
Relative. Your ladyship is correct. It was at trial, he said, more familiar with his brother Eric. Just provide the court with that particular...
So page 54 is the statement, his original statement.
Yes, thank you, my lord. That's the reference to... I recognise one of the gentlemen as a relative of a man I know by the name of Bishop, and I recognise his face because I see him frequently in the Dorset Market Street. Then there's the reference a few paragraphs down to 5'10" tall, slender build, and light brown complexion. My screen is just... The deposition is at 69, page 69, and we've looked at this before in relation to the recognition, the doc identification. Now, in relation to who he knew, you see, he says there at the deposition, page 71, there are two persons who normally hang out by Shamanzi's shop and who call out to me when I pass, and that's accused #1. Now, accused #1 is Ingle Rawlins, because Nardis Maynard is always described as #2. And we can just go back to page 70 there, towards the bottom of that page. The gentleman facing east that night was wearing a white T-shirt and had dreadlocks, that's the deceased. Accused #2 was also wearing a white T-shirt that night. I think that, you see, it should be that the assailant was also wearing a white T-shirt that night, but Nardis Maynard has, throughout the trial, was always referred to as #2. And Ingle Rawlins, his co-defendant, who was, case was after the half-time submission successful. He's #1. Now, if we go back to the actual evidence that Jason Hamilton gave at court, at page 94, let me just get that, Jason Hamilton, 95 to 97 it is. Now, it's at page 96, and I don't want to take anything out of context, I just want to make sure that nothing's being looked at in isolation.
Well, on 95, he says he's known both of them for 12 years. That's line 22.
I know the number 1 accused is Taj, and the number 2 have known both for about 12 years. Just Jason Hamilton, as soon as I came out of Hanley's, I went to, in all my observations, I only saw 2 persons interacting. I know number 1 for about 12 years. But this is obviously after this is some months after he's made the doc identification and the deposition. he never said in his witness statement that the person that he had identified that night, who was 5'10" and a relative of Bishop, was somebody that he had known for 12 years. He never said that he knew him for 12 years until he gets to the trial, and after he had seen Nardis Maynard in the dock. He had never said in his witness statement that the assailant, that the person he'd seen talking to the deceased, was somebody that he had known for 12 years. In fact, he had distanced it as somebody's, he said it was a face he had seen, but
that number one, he's talking about number one, isn't he? That's Ingle.
number one is Ingle Rawlins.
See, he doesn't say he knew the appellant, your client, for 12 years, does he?
He does.
It's at the
Oh, he
top.
does he?
Previous page, line 22.
95, line 22.
Line 22.
Page 95.
Both for about 12 years. Yeah.
Page 95. Sorry. Yes, I see. I've known both, right.
Subsequently, when he's cross-examined, he says on page 96 at page 20, I typed out a statement and gave it to the police. I'm not sure when. I did not make a statement. I'm not sure if I made mention of number two when I made the statement. Witness shown statement. I made no mention of number two. I got to the area and then he describes it. When I came out, there were two persons. Number two was nearer the fence. Rasta man would have been facing him. I did not attend identification. And then when you go down to page 97, he says, I know number one for about 12 years, but it wasn't the first time that he'd seen number two.
Very confused.
Yes, and
It's on page 96 from cross-examined by Mr. Vera. Page 96, line 18. There was a zinc fence. I don't think there is a wall. I recognised number two when I was passing. That was not the first time I was seeing him. I am more familiar with his brother, which doesn't really accord with knowing him for 12 years.
no, and again, it's not something that he had identified in his witness statement, that the assailant he had known for 12 years. So there does seem to be at odds.
But also, what does it mean I made no mention of number two?
I think he means his name.
Oh, I see.
His name, because the specific reference within his statement was 5'10", and as we've said, the relative of Bishop, and then later more familiar with the brother Eric. So that was really it. Now, Jason Hamilton, just dealing with height. Jason Hamilton refers to somebody, the assailant, being 5'10". Mark Handley, PC Hanley, refers to somebody that, but only in his from his deposition stage, as the assailant being short. Now, the written documents have all proceeded on the basis, as we understood at the time, and it's been corrected, that the appellant said there was 5'1". In fact, it's just over 5'6". Although that point significance is reduced in that he's clearly taller, the appellant is clearly taller than what we first thought, the inconsistencies in height as regards an individual 5'10", in contrast with what Mark Handley, PC Handley, was saying, was that somebody short ought to have been put before the jury. There's this inconsistency in height. And again, that wasn't identified, it wasn't flagged up for the jury. And again, it goes to the reliability, the inconsistencies, the potential weaknesses in the context of a situation where it is dark, artificial lighting, people watching an incident. The other points that weren't put before the jury were that the jury was aware that the assailant was left-handed, and the jury was aware that the appellant was left-handed because it was a specific question, in fact, that the jury asked during the course of Nardis Maynard's evidence, which will be at page 114. But during the course of his evidence, the jury asked him a question. The jury asked a question, and he said he was left-handed. But it was also part of the evidence from a witness, a prosecution witness, Prudencia Gayton, who said that she knew Baldhead, and he was left-handed. And Baldhead is Vincent Maynard. Again, that came PC Sutton. The officer in the case had been provided, he'd been given, it was a telephone call, an anonymous telephone call, shortly after the incident, where the person said, "Go look for Cutie's son, Baldhead." And Vincent Maynard was arrested in the early hours of Saturday morning when PC Sutton was at the police station. He then gets the call. They go to the hospital first. From the hospital, because PC Sutton speaks to PC Handley, and PC Handley knows Ingle Rawlins, and that's how they come to go to Ingle Rawlins' house. They arrest Ingle Rawlins. He has washed some clothes. They had noticed that Ingle Rawlins has some bruising to his hands, and he explained that he'd fallen off a step. They arrest him. They take him to the police station, and it's only after that that they go to the appellant's house, and they see the appellant in his yard. He's there at home. And it's when the police are leaving the house, Nardis Maynard's house, that they see Baldhead, Vincent Maynard, coming along the road on his way home. Now, this was obviously, it was 2 o'clock. PC Sutton says it was really 2 o'clock in the morning when he starts his different journeys to the hospital, then to Ingle Rawlins, and then to Nardis Maynard. So it was well after 2 a.m. when he gets to Nardis Maynard's house and arrests Vincent Maynard, the other brother, who is left-handed, who was the first suspect, and he's taken away for a few days, questioned, and then he's released. And again, we don't know what, except, if I could say, that PC Sutton did give evidence that he had spoken to Kamisha Powell and Marilyn Lowry before Nardis Maynard's arrest. But critically, we do not have We do not have any notes, and there doesn't appear to have been any questions about, what was said by those individuals before he was arrested about the assailant, because all we have is Marilyn Lowry and Kamisha Powell's witness statements, which are dated 2 days after his arrest. And that's when they're taken. That's the date of the statement, and in particular, I think it's Kamisha Powell's statement is timed. So they're taking the statement on that day. So 2 days after his arrest, we do not have any notes, any statements, or what these witnesses have said to the police prior to those witness statements 2 days after Nardis Maynard was arrested.
Can you remind me when he was arrested?
He was arrested on the Monday, the 24th of...
So after their statements?
Their statements are dated, their statements are dated the 26th.
Yes, so he was
2
dated
days.
2 days before. He was arrested 2 days before.
Yes.
Had his brother Baldhead been released by then?
It seems to say that we're not sure. The impression we get is he was.
He had been released.
It seems to be because, they say that they had Baldhead for a few days, yes, and then they went to arrest Nardis Maynard at his home.
And the
on
statements
the Monday.
come after his arrest?
Yes, they do. They come 2 days after his arrest. But PC Sutton said he had spoken to spoken to these witnesses before the arrest, but we have nothing. We don't know what those witnesses said to PC Sutton.
Or how long before the arrest?
Or how long before.
But there's no evidence linking this crime to Vincent Maynard that we've got, is there?
Well, the other problem was that Vincent Maynard was arrested coming back. So only hours after this incident, he was coming home. So they had him clothed, and they took him into custody. Yet at no stage, no stage were his clothing ever examined. No scientific forensic analysis conducted on his clothing. There was scientific forensic analysis conducted on the appellant's clothing. We accept, of course, that was 2 days later, but Nardis Maynard did say that he would provide what he'd been wearing, a top and shorts, and his clothing was analysed, and there was nothing linking Nardis Maynard, the appellant's clothing, to the crime. Vincent Maynard, who'd been picked up in the early hours of the Saturday morning shortly after the incident, had been released without his clothing being tested. And
do we know what he was wearing when he was arrested?
No, we don't. And they didn't. There's no note of that. But there is evidence linking to some extent, because he's left-handed. So, and the assailant is left-handed. So there is some basic.
None of the identification evidence. Nobody's suggesting that it was Vincent Maynard.
It's not a binary. We're not saying, well, if it's not the appellant. There is evidence to link Vince. Well, somebody called and said, "Look for Baldhead."
And of course, he would have been a relative of Bishop as well.
And indeed. And unlike Vincent, we were at home, albeit it was different. It wasn't within the alibi time frame. Vincent Maynard was coming home. He'd been out where he was. Obviously, we can't say, but he was coming back when the police were there. He's left-handed. And of course, yes, he's a relative of Bishop.
Were there any notes of what the appellant was wearing when the police attended on the night of the assault?
All they say is that when they attended, he didn't have his top on. He was out in the yard with shorts.
But they didn't identify cut-off jeans or anything like that?
No.
Did they search the property?
PC Sutton was asked this. He said, at the time, we weren't focusing on the appellant, Nardis Maynard.
No, but Vincent lived there too.
Yes.
So did they search the premises?
As I understand, not at that time. They just took Vincent Maynard to the police station, and of course it wasn't until the Monday that they arrested Nardis Maynard and took him away. They went back to the house, and he had been sleeping, and they took him from his home. Dealing with, sorry if I may just find something. Thank you. So those are the main Marilyn Lowry, Kamisha Powell, Mark Handley, Jason Hamilton, and PC Sutton. So those are the main witnesses, and we've tried to demonstrate how there were weaknesses, inconsistencies that weren't drawn out for the jury.
May I ask you about a point in your written case, which refers to something you've said very recently, which is on electronic bundle page 424, Roman numeral 7. This is Miss Powell and her mother, Miss Lowry, not or failing to provide the applicant's name, but you said that nobody knows what was asked of them.
I'm sorry, let me just get the page 44 of the...
It's page 30 of your written case, electronic bundle 424.
Oh, yes.
424.
Yeah.
And you say that nobody knows what was asked or said when police went to see Miss Powell and Miss Lowry before they gave their statements. But in Roman numeral 7, you say that each failed to provide the appellant's name and a description to the police officer at that time. Are you referring to on the day?
What I'm referring to, thank you for that. What I'm referring to is that on the night when the police arrived at the scene, when Kamisha Powell went out to the veranda to join her mother, they both refer to, in their statements and their evidence, that a police officer was on the scene and he was on his cell phone, is how they describe it. And the point, most of us would make, well, there's a police officer, there is somebody, and you say you know who the assailant is. You say it's Nardis Maynard. So why, at that point, did you not go and tell the police that this is Nardis Maynard? Now, the Court of Appeal said, well, you know, there could be all sorts of reasons why people don't say it, but that's a matter for the jury to weigh up, surely. Let the jury weigh that up. But it's something that, if they were so confident that this was Nardis Maynard, and there's a man lying on the street, and they know who's done it, well, then why are you not telling the police officer who it was? So that was in relation to the very night of the incident. PC Sutton, in his evidence, refers to having spoken to both women before the arrest. Again, we don't know when that was, but there's no note of that conversation. Of course, there is, just as an aside, the witnesses, both Kamisha Powell and Marilyn Lowry, were cross-examined by Dr. Brown and Anthony Johnson, the defence team, on the basis of mistake. Of course, the appellant in his evidence, maybe in trying to understand why, said that there must have been some sort of grudge by these witnesses as to why they've identified him. It's just a point of interest that P.C. Handley in his evidence talked about hearing the deceased refer to them all, rather than boy, sort of, what are you doing? He hears words that what are they doing, as in plural rather than singular, whereas the two women refer to hearing the deceased say boy, as if identifying that one person whom they say they know.
Sorry, I don't.
Yes, it's just in relation to the grudge point, really. I mean, it's not something that was picked up, and it's just there's a difference in what individuals hear the deceased say about what's being done to him. And the two women refer to hearing the deceased say boy.
So you're saying we should infer that was part of the grudge?
Well, they're
pretty speculative.
It is, but it's just a distinction between the witnesses.
It's fair to say that the judge drew the jury's attention to the grudge point, and clearly the jury didn't buy that point.
Yes, as a general term, but in relation to the identification, in relation to what weaknesses are there in the identification, what inconsistencies, we say there are none. There is none. And there are a whole host of authorities which we've put before the court, beginning with Turnbull and the specific weaknesses. And just a balanced approach, but by looking at the summing up, it highlighted the general concerns of identification, and then, of course, summarised the prosecution witnesses' evidence, and then referred to the defence case as well. He said, the appellant says he wasn't there, he was at home, but at no stage was there this analysis, this assessment, this look at what these witnesses are saying, look at the inconsistencies, think about the timings. Could it 15 to 20 minutes as opposed to 3 to 5 minutes? And of course, the court recognises that there were some defects in the identification, but the Court of Appeal recognised that they weren't sufficient to quash the conviction, and in circumstances applied the proviso. And just dealing with that here in relation to identification and the proviso, we say that there were significant defects, not just one or two. There were a number of identification recognised by the court in relation to the timing, in relation to the inconsistencies in height, and that what Kamisha Powell had seen, what her mother, compared with what her mother saw when she was watching for 10 to 15 minutes, and just making the jury think about the contrast and the weaknesses. But in Casale, Lord Hughes had said, obviously, the more defects there are, the more impact it clearly has on the conviction.
I think one of your points, Ms. Gray, is that the Court of Appeal seemed to be straining to overcome the weaknesses, even though they acknowledge them to exist. and gave explanations and speculated as to why things had or had not happened, which favour they did not give to the evidence potentially of the sister of the appellant. So what you're saying is, who knows what the jury may have made of it, but looking at them all together, which the court seems to have agreed with you pretty much whole scale, that this should have been before the jury, because you're going to go on to link it cumulatively to the other points of criticism.
My lady, yes. I mean, obviously these points we say stand individually, but really they're cumulative. They all work together. And it's looking at them together, because the identification, the alibi, we will turn to that, the alibi evidence is significant in two ways. The alibi evidence obviously undermines the identification, and secondly, it's there to substantiate, to support what the appellant was saying in his own evidence, that he'd been at home with his sister and with his brother Terence, who sadly died in 2012. So it may be an appropriate time for me to move on to the alibi.
Well, is it your case that you're saying if one takes the Court of Appeal to have accepted your criticisms and acknowledged the weaknesses, that therefore they should have reflected those weaknesses in their consideration of the alibi issue?
My lady, yes. If we may now turn to the alibi, which is in dealing with the alibi, it's ground one, and it's at the electronic bundle, page 408 of the skeleton argument entitled Appellant's Written Case. Now, just dealing with the we say that the alibi, Yvette Maynard, the appellant's sister, her details, along with her brother Terence, we called him Terence Maynard. He also went by the name of Johnson, Terence Johnson, and he died in 2012, and that's what the death certificate is named as Terence Johnson. But Terence Maynard and Yvette Maynard were named as alibi witnesses in August 2003, when the attorney wrote to the court and to the prosecution, setting out in clear terms that they rely on Yvette Maynard and Terence Maynard from Prickly Pear Avenue. The prosecution, Mr. Merchant, who in fact was the prosecutor at trial, he'd been CC'd into that, and prosecution respondent asked for witness statements, wanted the alibi witness statements. But of course, in the supplementary bundle that's been placed before the court, there's reference to let me just have a look at the actual statement, to the letters. The letter from the Director of Public Prosecution to Anthony, the attorney, it's at page 275.
Sorry, of the main bundle?
Of the electronic bundle. It's at 275. 274, in fact, is Dublin and Johnson, the defence solicitors, writing with Yvette Maynard, Terence Maynard, Prickly Pear Alley, Basseterre, St Kitts, and the response. And in fact, that is dated the 25th of August. There was a hearing at court on the 29th of July 2003, where is the standard, they asked the appellant through the solicitors whether any alibi is going to be put forward in court at that stage, or you have 28 days in which to do so.
But he said no.
He said no,
Yeah.
but the rules are that you have 28 days to put forward the details. And as we can see from the letter dated the 25th of August 2003, the details are provided, and they're provided CC Dennis Merchant, who is in fact the prosecutor who prosecutes the trial. And so both the court and the prosecution were aware of the names and addresses. And I just make the point, at no stage, it's part of the investigation, we at no stage, and I don't seek to minimise it in any other way at all, it's just a point of observation that the prosecution, it doesn't appear that they went and spoke to the alibi witnesses at any point. They were provided with the information.
They wrote back and said, can you give us copies of the statements? That's the next page, 275.
No, the prosecution themselves never went and spoke to the witnesses. The prosecution, had available to them the names and addresses of the alibi witnesses, and at no stage did they investigate whether was he at home with you too? They had access to the information. Now, the prosecution wrote back and said, now the trial was in July 2004, so the defence were providing the information just under a year before the trial. The prosecution asked for the witness statements, but there's no, according to the Law Reform Miscellaneous Provisions Act 1998, Section 30B, the obligation on the defence is really just to provide the names and addresses. There's nowhere in that act that says that the defence are to provide witness statements to the other side. It's simply the name, provide the obligation, the duty is on the defence to provide the name and the addresses.
Well, that's how it used to be in the UK as well, before the defence case statements became the norm. But in this case, taking you on, I'm sorry, out of your chronology, one would have expected those who represent the appellant to have gone to see what the witnesses were saying and to have taken a statement in order for them to notify the names and addresses to the DPP. But we don't have those at all, do we? In fact, we have reference to the fact that nobody knows why they weren't taken.
Your Ladyship is correct that this takes us to back in 2015. Those that instruct us, Simons, Muirhead and Burton, contacted Anthony Johnson and Dr. Brown in order to try and understand what had happened. First, where are the papers? The defendant has made mention of being with his sister and his brother. Were any alibi witnesses called? The correspondence is in the bundles. Anthony Johnson and Dr. Brown were both contacted about the alibi, about the failure to get to no direction in relation to character, and reference to identification. So all the points that we've raised here at court were all asked of both Anthony Johnson and Dr. Brown, as well as, of course, the abandonment, the nullity point. Anthony Johnson said in response, in his correspondence, was that there was a set of papers, it had been put into storage, but they didn't have those papers anymore. Now, I accept that that was 11 years, it was 9 years after the appeal, but there were no papers within the hands of the solicitors at that time. He responded that he couldn't answer, he couldn't provide any answer as to why any alibi witnesses why they weren't called, whether any statements were taken. There was no positive answer. Simply, we were met just with I don't know, I can't remember. And Dr. Brown responded by saying, well, I really basically just helped out Anthony Johnson. Really, you need to speak to him about it. I simply assisted. But of course, we know from reading the material from the trial that Dr. Brown was leading counsel. He cross-examined all the witnesses except for one. He dealt with the half-time submission. He examined in chief the defendant, and he conducted the appeal. So to say that he simply assisted Anthony Johnson is not right. But he could provide no answer. So we were left with simply, we do not know why Anthony Johnson, in August 2003, had the names and addresses of the alibi witnesses, and clearly the defendant gave evidence in accordance with that, because he told the jury, I was at home. So nothing had changed. His evidence was, I was at home with my sister and my brother. The Court of Appeal said, well, there are all sorts of reasons why they may not be called. Things may change. The witnesses may not appear credible, but that we submit cannot be right, because Yvette Maynard's affidavit makes clear that she wasn't spoken to by the lawyers, that she never made a witness statement. She was at court to support her brother, and she wasn't allowed into the court. She was there to support him, but at no stage did she provide any information, any witness statements, and unless the lawyers have spoken to the potential alibi witnesses, how on earth can they weigh up whether they are credible or not? If they haven't been provided with a witness statement, how can things change? It's only having spoken to the alibi witnesses that you think, well, maybe this doesn't look like it's going to stand up, and then there's credibility issues. But the fact that Yvette Maynard, and there is evidence from her in the form of the affidavit, that she wasn't spoken to by anybody. So when the Court of Appeal say things could have changed, how in these circumstances could things have changed when there was no witness statement, when there was no discussion with the alibi witness? And of course, Terence Maynard died in 2012, but Yvette never spoken to, she said. So things changing, that is not this sort of case, we submit, because you would need to have spoken to and need to have been provided with that witness statement to make those changes. So just dealing with her, in fact, the Court of Appeal said that they didn't find Yvette Maynard's statement credible, but this is not a statement that was an exaggeration. In fact, if she'd say, well, I was in the room with him from 12 to 1, for the whole time that you say that he was meant to be somewhere else, no, what she says is, I would know when he'd go out. The TV was on. When he'd go out, he'd let me know he was going out. And not going out to the yard, but going out into town. Yes, she could have been cross-examined on certain issues. Well, so the case is you didn't actually see him in the room, but it's part of the narrative. It was for her to give evidence and for the jury to weigh up what they thought of her, whether they thought, well, it's supportive. She's saying that he would have said, I'm going out now, and that didn't happen that night. So the Court of Appeal also, we submit, gave credence to, well, it seems observed that she would have been standing on her bed and looking over, because what she was saying was that there's this partition. Her room was next door to the appellant's room. And there is a partition wall which doesn't quite reach the ceiling, so her bed is up against the wall, and if she wanted to peep over and see her brother, she could have done by standing on the bed. But she's not, in fact, saying she was doing that night. That's how she could have seen him. What she's effectively saying in her affidavit is the TV was on. If he's going out, he'd have told me, and that didn't happen. So, not a case of I was standing on my bed all night and I was looking over. So we say that to arrive at the point, and we did in fact give the court obviously the option of, if you want to hear from Yvette Maynard, I mean, it was heard on the papers and just after COVID over the video link, and she didn't give evidence. We submitted that there was, if the court wanted to hear from her, then she could give evidence and expand perhaps on anything that they were maybe concerned about or sought clarification of. But we submit that there's nothing in her statement about the alibi, about that night, to suggest that it lacks credibility. And again, this is a statement that's being taken, a long time after, even though she said, look, I could remember what I was wearing. I was pregnant with my child, so I can remember. But of course, yes, she's trying her best, but it is indeed a statement that was taken many years later. So there could, had it been taken at the time, there could have been more information in there that we simply, over the passage of time, don't have. But we submit that the detail, what she was saying there, could have assisted the jury, and it was entirely a matter for the jury to weigh up. The Court of Appeal also seemed to give weight to the fact, well, Sergeant Sutton, the officer in the case, had gone round to the house later on that night, and perhaps that could lend support for the alibi. So, you don't really need to have Yvette there, but that can't be right, because we know that PC Sutton became aware of what was going on at 2 a.m, goes to the hospital, then goes to Ingle Rawlins' house, and it's only after that. In fact, I think he goes back to the police station and then goes to Vincent and Nardis Maynard's house. So that's long after. We know that the killing, the stabbing, happened between 12 and 1 a.m. in the morning on Market Street, between 12 and 1. So the alibi, the critical time, is between 12 and 1, not long after 2 a.m. in the morning. So Sergeant Sutton's evidence of when he went round and saw Nardis Maynard in the yard at home is not supportive of alibi. Then he sees Vincent Maynard, bald head, walking down the road that came. But so we say that that's not of any assistance, that what was of assistance was Yvette and Terence Maynard, because there is the appellant on his own. He gives evidence. He goes into the witness box and he gives his account. And we say, we stand by it, that the jury must have thought, well, where are your brother and sister? Where are they? Why are they not here to support you?
Well, you say it could have assisted the jury, leaving aside whether it was getting over the sort of credibility and fresh evidence. I suppose the Court of Appeal might be regarded as saying, well, it was so weak that it actually couldn't have assisted the jury.
That's, well, it's... What Yvette Maynard was saying was that he was home because if he's to go out, I mean, the TV was on in his room, if he's to go out, he would tell me. And he didn't tell me he was going out.
But he did go outside.
To the yard. What was meant, yes, he went into the yard, but still within the confines of the property. I think when she means go...
No, she didn't say, I noticed him going out to go to the yard.
No, but I think, and again, perhaps if she'd been called, this would have been clarified, but going out, I think as in going out to town, leaving the house.
There are two aspects to this, actually. In paragraph 14 of her affidavit on page 155, she says, if he left his room, I would have been able to hear him open and close the door. That's my lady's point. And then the next sentence is your point, I think. And he always told me when he was going anywhere, any time he left home, I would know. So there are two aspects to that. And the first aspect, I think you're saying, well, she could have been asked about whether she heard him go out at all during the night from his room.
His TV was on. If he left his room, I would have been able to hear him open.
That was the bit that puzzled me. If his TV was on, how would she necessarily hear him? But anyway, that no doubt would have been a question for the jury.
And he always told me when he was going anywhere.
Yes.
Any time he left home, I would know. Now, home...
Well, let's assume that means, clearly it suggests the premises, which would, so if he went into the yard, he hadn't left home.
We submit that the court were caught up in the fact that it lacked credibility. We submit that it's, in fact, the opposite. It's not somebody who's exaggerating the position, but somebody who's just telling it like it was.
Well, perhaps relevance and cogency might have been a better word. But, my Lord's point about the weakness of it, is that a point you want to address? Because we know he did leave the room. She didn't hear the door open and close. She doesn't say anything about that.
Surely that's a matter for bearing in mind what she says, that, and he always told me when he was going anywhere, any time he left home, I would know.
Well, so she says, but she didn't know that he had gone out into the yard.
But clearly it would have been a matter for the jury to weigh up.
But before you get there, don't you need to get over a hurdle of sufficient cogency to call evidence 15 years later, or whatever it is?
Well, we submit that in itself, that he always told me when he was going anywhere and any time he left home I would know. It is sufficient, and this wasn't a case where as I say, she had exaggerated it and was just telling it like it was, and that if it's credible, if the evidence is credible but not fresh, then the court weighs up its strengths and its potential impact on the safety of the conviction. And the fact that the appellant had named his sister and his brother as alibi witnesses, it would have clearly, we say, had an impact with the jury on why they weren't called.
Well, you've got these.
The other hurdle you have to climb over is coming up with their explanation for this evidence not having been deployed at the trial. The onus, I think, is on you for that. You complain. Understandably, I have every sympathy that there's a sort of deafening silence. But what we do appear to know is that she came to the courthouse but wasn't allowed into the hearing. Would there be any other reason for not allowing a relative into the hearing than that they were still contemplating calling her as a witness, in which case you presumably normally keep the witnesses out of the hearing?
My lord, that's correct. She was pregnant at the time. This wasn't a child. You know, there's.
But what goes on from that is, it looks therefore as if they were keeping their options open right up until the time of the trial, whether to call her as an alibi witness. As leading junior counsel conducting the case, the inference that they decided not to, bearing in mind she was there, and they must have known she was there, they said, I mean, I'm putting together the inferences to be drawn from her not being allowed into the hearing. His team must have said, no, don't let her in the hearing. They hadn't at that stage decided not to call her. It looks as if there was a late decision not to call her.
The information that obviously comes from Yvette Maynard's statement that she wasn't allowed into court. We don't know. She doesn't say why she wasn't allowed into court.
No, I know, but it's a little bit of evidence which just helps one a little bit further forward as to what may have happened in a situation where the burden to come up with a reasonable explanation is on you, not the other. It's not the other side to show that there's no reasonable explanation.
Implicit within this, and may I say this, implicit within this entire appeal has been, of course, issues around trial counsel. Now, we are very careful, and one has to be. We know that it happens a lot, and people can jump to those conclusions, but we are very careful about making allegations against other counsel because of consequences. And we did do everything we could to ask counsel for what happened. We went down that road, and we've been. It's not a case where we would be making criticism and we didn't ask them what happened. We did everything we could in 2015, 2018, and then when Dr. Brown provided his affidavit to say that at no stage did he ever speak to the appellant, that he was given clear instructions by Dr.
This isn't a criticism of the diligence of your team.
No.
At all. And it doesn't suggest any lack of sympathy for the fact that Mr. Johnson's not able to help. These are all very unfortunate, but at the end of the day, where the burden is on your side, one has to do what one can to try and see what probably happened.
But
I mean, what I take from your submissions, just to cut through this and be blunt about it, in the light of what you have said in particular, that defence counsel never spoke to Yvette, never took a statement from her, had no idea what she was going to say. The only reasonable explanation for the failure to call her was total incompetence. Now, you may not want to use those words, but that's what I infer from your submissions.
my lord, yes.
Thank you.
Presumably, you would say, Miss Gray, that on the basis that the appellant gave evidence, excuse me, that he was at home, then whereas his counsel and solicitor may have thought, well, we don't think that the sister is sufficiently independent or may not be able to give enough evidence, that there was absolutely nothing to lose by calling her. That's the thing that you're saying. And for them not to do so, when one looks at the fact that Dr. Brown decided to abandon appeal without instructions, one starts to put inferences together rather than speculate.
My lady, yes, yes. And factored into that, of course, was the reference by Dr. Brown to saying that he was full of remorse when clearly there was no, that the appellant was full of remorse when clearly there was no basis for doing so.
Well, Dr. Brown thought he could do a better case without his client.
Obviously, I'm looking at the timings. Just in relation to that point on alibi, that the Court of Appeal said that Yvette Maynard would have an interest to serve, and therefore they were concerned about her evidence. With alibi witnesses, more often than not, it's always pretty much going to be people that are known to the defendant, family or friends. And there is a passage towards the end of Turnbull, in fact, where there's reference to a wife giving evidence for her husband, saying that he was at home asleep. And they said, well, yes, it's the wife, but that's just the way it is, and that's for the jury to weigh up. So we submit that because it was his sister, we don't submit there's any interest to serve, and that it could be looked at as it was. So those are the submissions, unless I can assist. We're going to turn to the character evidence, and may I hand over to Mr. Varden for that, please?
Can I make the point in a necessarily brief way? As far as the lack of a good character direction is concerned, whilst I accept that's a discrete point, it cannot but be looked at in the overall context of the case. The submissions I make are these. An important and significant good character direction was not given to the jury. That is, of course, a fact. Secondly, the good character direction, both limbs of it, was the appellant's right. Thirdly, I recognise that the lack of a good character direction may or may not be fatal to a conviction, depending on the facts of the case. And in terms of the facts of the case and the context of the case, I make the fourth brief submission, and it's this. One, there were other issues, as my learned friend Miss Gray, King's Counsel, has dealt with, which give the court cause for concern in this case, stemming from the questions of counsel's approach to the case all the way through to the inadequacies of the summing up, particularly as it related to identification. But secondly, there is another issue in terms of the context of this particular case. That is, the appellant's case was essentially passive. All he could say was, it was not me, I was not there, I did not do it. And in that context, a good character direction is of particular importance. I briefly turn the court's attention, referred to at paragraph 81 of the skeleton argument, to the case of James Williams. I don't recite in the time available facts, but in terms of the appeal, it's pretty clear that it was the failure to give a good character direction which was at the heart of the decision to quash the conviction. If I may quote from Lord Justice Elias, the case therefore turns significantly on his credibility. He had an army of prosecution witnesses who were contending for the contrary. In those circumstances, it seems to us that the good character direction was potentially particularly important because it was one of the few supporting pieces of evidence in favour of the reliability and honesty of his account. If that
what paragraph are you reading from?
Oh, I'm so sorry, my lady. Paragraph 83 of the skeleton argument.
What paragraph of Williams?
So sorry.
Paragraph 20.
20, thank you. Yes, I see.
And if that was true in respect of a driving offence, so much so more in respect of murder. And of course the case further referred to at paragraph 84, McCleary, indecent assault case, credibility of course being the main issue. a full character direction in that case was found to be quite essential. So here we have in that context witnesses, two of which purport to recognise the appellant, a third witness against him. That's really the entirety of the case. His credibility and his propensity were vital issues in the context of this case. Can I finally just comment really, in the time left, to mention the approach of the court itself, because in terms of that, the court indicated that they were considering the issue of Bola, and the critical question they went on to discuss is whether it would have made a difference to the result had the good character direction been given by the judge. They said it would not. They went on to say, in fairly extraordinary terms, the evidence against Maynard at the trial was compelling. In the light of the cogent and compelling identification evidence, as well as other evidence against Maynard at the trial, it cannot be said that a good character direction would have somehow changed the view of the jury that Maynard was guilty, and therefore cannot be concluded the judge failure to give good character direction undermined the safety of the conviction. Well, it's a matter, of course, for this court. A compelling evidence, compelling identification evidence, what that other evidence that they refer to was over and beyond the identification evidence is, I say respectfully, anyone's guess. So the good character direction is really right at the heart of the appeal, but it has to be looked at in combination with the other grounds which have been put forward by the court. And it is finally said, really, that in relation to Bola, we say that there was a wrong question posed, that the question posed whether it would have made a difference to the result of the trial had the good character direction been given by the judge. The question should have been, are we satisfied that the failure to give the direction would not have made a difference? And for those reasons, and I'm usually on time for counsel, I leave it at that.
Thank you very much.
So you say in paragraph 72 of the Court of Appeal's judgment, the reference to as well as other evidence against Maynard at trial is mystifying.
Totally.
It can. The only possible matter could be him being left-handed.
Yes, which is really hardly compelling. Thank you.
Ms. Reed.
I'm sorry. I will try not to go over detail in relation to the papers that has already been dealt with. I'll start with the identification sufficiency from our point of view. I'd like to start with just perhaps summarising the features of the identification evidence, which we say allowed the Court of Appeal to refer to it as compelling evidence, because they did. And when I deal with this, I'd like to highlight why there were differences in relation to time, in relation to length. It won't surprise this court, with the experience you've had, all of My Lady and My Lord, that it's very difficult when witnesses look at a violent incident and it's a moving incident. You expect differences. It is even surprising to many people, but quite common. You can both look at an incident and one of you misses an aspect of it, but you were standing there watching the same incident. I simply make those two general points and invite you, I know you have it in mind, to keep that in mind as well. The differences in Miss Powell and Miss Lowry are important because the aspect of the defendant's case, which he presented to the court, was a little detail, an important detail for his case, about the fact that he took the view, both of them fabricated the evidence against him because there's a grudge. I can just remind you of what it is, because it hasn't been touched on, but it is actually important. When he gave his account in trial, EB 116, it's not very long, but we ought to just keep it in mind, because this crops up later on. And just to refer to it very quickly, I know you would have read it. I've lived in Bricklepear Alley all my life. I've just gone back to 115, at the bottom of that page of 115. Kimisha, Miss Powell, did not live in Bricklepear Alley at the same stage. Well, there is no evidence that these alibi witnesses ever lived in the same road as the appellant. I'm not sure why he made that comment, but Bricklepear Alley has been his road all his life. There's no evidence at all that the two alibi principal witnesses lived there. Her mother did not live on Bricklepear Alley at the same stage. Again, I'm not sure the relevance of that, but I won't dwell on it, because it's clear they didn't. It is a lie that Kamisha knows me for all her life, which probably means that he's accepting that she did know him for part of her life. That's a possibility of the interpretation. I just know she's downstairs in the PI. She does not know me all her lifetime. Her sister's boyfriend and me do not get along. Kamisha's boyfriend. We heckled Kamisha's boyfriend. I don't understand what's in the brackets, but pieces that he's supporting a whole family, he didn't like it. That's why they lie on me. Marilyn would come, lie on me, maybe because the daughter and me don't get along. They've hated me since 2002, sorry. I don't know, and we'll never know, why these matters were not put to both witnesses, so one could understand the response they would have given to the question of, was there a grudge? Did he fall out with your boyfriend? None of that was put in the transcripts at all. I've checked it, my junior has checked it, there is no reference to it. But it is his evidence, it was given on oath.
Just before you leave that, and it may be elsewhere, but what does PI refer to?
I was hoping you wouldn't ask me, because
Okay,
I
we don't
have
know.
never been
Right.
able to find out. So forgive me. So we do want to bear that in mind when we come to the relevance of the identification evidence. Now, we know and understand that on a careful reading of both these witnesses makes it clear that the mother views something happening outside first. And the statements are all quite clear about that. Her daughter, Miss Powell, is in another room at the table having a late night snack, because that's her account. Sticking to the mother for the moment. And I've got some accuracy of some of the events. I can give you references so that you keep them and check them perhaps for yourself. Miss Lowry first heard two males arguing. That's what drew her attention. EB 84 to 86. So she goes to the room she's in, which is her bedroom, because it has a window. And the window overlooks the place where the altercation took place. And at EB 84, she says that she sees a dark rasta male, Daddy Screw, from Upper Prickly Pear Alley. So she's got the address right. It's important because it's part of the recognition. Daddy Screw is his nickname. She does go further to say in 84, Daddy Screw, other name Nardis Maynard, known for over 5 years. So that is what she knows about him. Again, that adds to whether or not this was in any way fabricated. I've gone through that. We can't go further because none of this was put to them. So we know where she is in the house. The lighting is important. EB 85. Lighting good. Lamppost right by my house. You probably won't get better than that in terms of lighting. We don't know what kind of light it is, but we must take it that the witness says it's very good lighting. The bedroom window was opened. She wasn't just looking out through the glass. EB 84 makes it clear it's an open window. In her evidence in trial, distance from here, where I am, witness box, to where the jury is. Well, we just have to guess that. I don't know how big the courtrooms are. I'll come back to this length of the observation in due course. So what did she see and what did she hear?
Just in terms of how far away it is, my understanding, but I may be wrong, is that she saw the incident occurring on the other side of the street. Am I right about that?
I think that's right. She doesn't specifically say that.
I see.
And I think I have got the references to matters that are put to her in cross-examination.
I see.
But certainly her daughter may say that.
Yes.
It's happening over there, but Nardis Maynard was in the middle of the street.
Oh, I see. Oh, was he? Oh.
Yeah.
In the cross-examination, that doesn't seem to be right, Miss Weeks, because cross-examined by Mr. Johnson. Yes, cross-examined by Mr. Johnson. The incident did not occur exactly in front of my house. My house is at the corner of Dorset Road. The incident did not occur exactly in front of Barman's house. In between my house and Barman's house, there's a little shop.
That's exactly.
It occurred close to the shop. The shop is on the same side as my house and Barman's house.
Yeah.
The shop was not opened. So, in answer to my lord, she seemed to be suggesting it was on the same side of the road as her house.
I think that's right, and forgive me, I've got it here and I should have gone straight to that. You're absolutely right, that's at B86, and it was the cross-examination of Johnson. So it sounds as if she's saying it's happening on the same side, in between my house and Barman's shop, same side as my house. That potentially increases her ability to be able to say she had a good position and a good view of what was happening. But the two things are there. It sounds as if one is saying that it's in front, slightly on the other side, but it is not bang in front of her house. And she does make that clear later on from one of the points that she makes. Yes, not exactly outside my house, close to the little shop in between my house and the Barman shop, same side. So I've also got that reference. Thank you for drawing it to the court's attention. The what she sees and what does she hear?
Sorry, just to go back on this, but at page 47 in the bundle, in her police statement,
That's a much earlier time.
very close to the incident, she says that she saw them arguing on the opposite side of the street.
Yeah.
So that's what she said 2 days after, or 4 days after, sorry, the incident.
Yeah.
So you're suggesting that was wrong.
I don't say it's wrong. I think these witnesses have given slightly different
Yes.
descriptions of where it is, and it's not always easy for them to say it's right in front or it's on the other side or it's nearer or slightly to the right, because the explanation about there's a little shop in between both houses.
Well, I understand that. It may not have been directly opposite the house, but was diagonal.
That's correct. And I don't know that it was bang on her side, because if she was able to view it so well, it's likely to be slightly more towards the other side of the road, as she was attempting to say in her first statement.
But anyway.
What is very important is she is watching an incident that is from her witness box to the jury. Because that's what she says about her position from where I am here to where the jury is. Now, we don't know if the jury was about the distance of about a street. Well, streets in a small island are not very large. So, forgive me for giving evidence like that. I didn't mean to.
Yeah, but we do know that there were cars parked on either side of the street.
There were.
And with enough space for at least one car to drive down the middle. So
Precisely.
that gives us a picture.
We're not speaking about a huge distance
No.
as such. And the importance of perhaps understanding with a very sketchy explanation of where exactly the incident took place, it was close enough for her to have a good opportunity to see and watch what was going on. That's the reason, perhaps, for making sure we look at that. This is what she heard. She refers to the Rasta man. We all know who that is. That's the deceased. And, of course, the person she recognises as being the person with the nickname Daddy Screw, known for 5 years. Over 5 years, forgive me. She heard the man called Daddy Screw ask Rasta for money. Rasta gave him money, and they continued the argument.
Well, she doesn't say that.
Sorry?
She doesn't say that in cross-examination, does she? On
Not
page
in-
85, she said, I saw another gentleman, the one that died. Nardis was asking the gentleman for money. The gentleman gave him something, so I stuffed my teeth and turned off to go to the bathroom.
Yeah, I was about to come to just deal with that, because she does say something slightly different. But she is saying, certainly in my, when we turn, I ought to give you the reference to her trial evidence. Maybe helpful if we go
Well,
to...
this is her trial evidence, isn't it? At page 85.
Yes.
So at trial,
but it
her
starts at
evidence
84.
is...
At 84, bottom of the page, she does say
That it's Rasta.
Nardis was talking and asking the gentleman for money.
Yeah.
Yes, but what she doesn't say is that money was given and they carried on the argument. That was what I was referring to, Miss Weeks, when you said that they carried on the argument, because that's not what she said.
Yes, I agree with that. I'll come back to my reference as to why that's in. I hope I can find that to make sure.
Can we just have the cross-reference to the cross-examination?
Yes, it's...
Yes.
Which page?
I think it's along 84.
Oh,
86.
No,
right?
84 is the
Evidence in
sheet.
Chief, 86.
It's 86. Chris.
86. Yeah.
yes, thank you.
Where she does incidentally say, I saw Nardis Maynard speaking to the restaurant on the opposite side of my house.
Yeah. So that's also part of what her evidence is about where
Yes.
she's seeing that. So I just want to go back a step to check. I heard two people outside arguing, and I'm just checking again. I opened the little window, looked outside, saw Nardis and the gentleman. Nardis was talking to him. It appeared as though he was asking the gentleman for money. I saw another gentleman, the one that died. Nardis was asking the gentleman for money. The gentleman gave him something. So I sucked my teeth, turned off to go to the bathroom. So that's much more precise about what exactly she saw and what happened. So she goes off to the bathroom. Her daughter is not with her. She says nothing about her daughter at that time, Miss Powell. So she sees some communication between them both. She couldn't have been looking for very long, and she does not describe a fight. She describes communication, and she understands the topic, it was money. And that the gentleman gave him something. She talks about the lighting. I observed them for maybe 10 to 15 minutes. Timing is different. It's difficult, forgive me, for witnesses. They do the best they can. And when one is recording what that is later on and judging whether it can be realistic, it's difficult.
Am I right in my recollection that they didn't have a clock in their house?
I don't think anybody asked them whether they had a clock or
I don't know
not.
where I picked it up, but
I think that's what Nardis Maynard said. He said he didn't have a clock in
Right.
the house
Oh,
because he didn't
okay.
know what time the police
Yeah.
had come to the yard, I think.
So this is all we hear from her, and then she talks about the street lights, and I observed them for 10 to 15 minutes. We would think that that's quite a long length of time for the smallness of what it is that she saw. But we must accept that witnesses give us these estimations. They're not necessarily lying. They're not lying at all. They're just saying what it is they felt the time was. What is important is there was nothing blocking my vision that time. So the very first time she's able to say who it is, somebody she's known for 5 years, nothing blocking her view.
I just asked Miss Weeks, it's slightly off-piste, I know, but if you look at her cross-examination, I think it's accepted that Vincent is Baldhead.
Yes.
And what she says is, I do not know Vincent Maynard. I know Baldhead. He is the brother of Nardis. I don't know whether he's left-handed or right. I do not know that Vincent was picked up by the police on the night of the 22nd of March. So whoever she knows as Baldhead isn't Vincent, so far as she's concerned.
Correct.
So do we know that if we're looking at speculating as some of the things that you've been saying do tend to do, she said Daddy Screw. Do you draw anything from the fact that she's mixed up Vincent and Baldhead with somebody else?
I have not so far, simply because Daddy Screw is his nickname.
Nardis
both,
is.
yes.
Yes.
And both the daughter and herself, you will see it in her statement, that they refer to him as such fairly consistently. I will say this, the answer could be she doesn't know the nickname Baldhead. What is more important, that I do not know Vincent Maynard. I know Baldhead is the brother of Nardis. I got it the wrong way around there. I know Baldhead is the brother of Nardis. But we now know, as those who are getting on top of this case, Bullhead and Vincent is the same man. That, we would say, doesn't affect a recognition in any way, but an important point to bear in mind. Mother is now left the window and she's gone back into the house. She's indicated go into the bathroom. I hear my daughter say something and then I got up. We don't know the length of time that she went away, then got up, and then went outside the front door of my house. She doesn't see her daughter en route. She hears something and goes right outside the house. She clearly has missed something of the altercation. That is obvious. I don't have a timing. She wasn't asked. She didn't give it. I saw Nardis and the gentleman that died. He was up the road sitting down. Well, it must be Nardis, because he's alive. The other Rasta man. From my front door, Nardis was from here to the witness box. That gives you another idea that he's not very far away, if one is to rely upon whom it is she now sees. Nardis from the witness box to where the jurors are sitting. She's used that before. Nardis was walking down the street. So the altercation for her is finished. She doesn't see any violence. But she sees this, which is important. He had, excuse me, he had his left hand under his shirt. It's important because we say her daughter gives that exact description. Nardis was going down the street and the gentleman was up the road, sitting down. That's the deceased. He's going away from the deceased, and then she tells you about what the Rasta man said. We don't have to go through that again. He was trying to get up, and she notices the front pants was wet. So that's an indication that he's already been stabbed. So she sees nothing of the real important feature of this case, the killing. And whether we want to deal with 10, 15 minutes, these estimations are never really reliable, but what is reliable is what she sees. How she describes it. If she saw part of his pants wet, that is consistent to where the blood was and to where the wound was found on his groin area. And it's pants that was wet. She doesn't give a specific part of it, but she's seeing something that can be corroborated with evidence that comes later, where the wound was. The deceased did say some words. She seems to have heard those words, which are similar to the words that Powell hears, similar to the words that one other witness hears. Mine immediately comes to fabrication, that this is a made-up story. His evidence is, you were not really, genuinely identifying me as somebody that was a stabber. You just put my name to substitute for somebody completely different to me. And that's the point of the grudge and the fabrication. But the best evidence to suggest that they have got their heads together to make sure that they bring this grudge now, although they didn't have any idea he was going to be there on the day, no notice that this was going to happen, so this was their chance for fabrication. All of that needs to be borne in mind when you come to assess whether this can be fabrication at all. Because the mother sees what she does see. These statements from mother and daughter were not taken until the 26th. So we're potentially speaking about Wednesday of the following week. This is Saturday, Sunday morning now. The event happens after 12, before 1 o'clock. They've had plenty of time to make sure that their statements are valuable enough to make trouble for Nardis. Well, she might have wanted to add that he was part of the stabbing. She hasn't said that at all. All her evidence is that he's there at the right time and the right place. But she does not invent a stabbing motion from him at all. That's important. The cross-examination we've already touched upon. Here is another aspect of there being no collusion. It's EB 86. It's the cross-examination of Mr. Johnson, and we're at 20 to the right-hand side, line 20. I cannot tell you that my daughter Kamisha looked through the same window. I think she looked outside. I think Kamisha looked outside too. The night in question, I did see Nardis Maynard, because the question must be put to, well, did you really see him? Nardis Maynard has several brothers. Here is another feature about the knowledge of recognition as to who it is she sees in this business of money and a little chat on across the road. While I was in my bedroom, no one else was present with me. And those are important matters that I've taken you specifically to the transcripts to indicate. She's on her own. She doesn't talk to the daughter about it. They are both interviewed on the 26th because their original statements have the date of the 26th. I'll just give you a reference if you want to go back to it. Electronic bundle 47 is for the mother, and the beginning of Lowry starts, yes, at 47, and it goes all the way to 51.
Ms. Weeks, what do you say about the evidence that Ms. Lowry gives on page 87?
I've got it.
At line 5, when she says that before she gave a statement, a police officer came to see her and to tell her what he had heard.
I think that's not the best procedure because we don't know what it is he said to her. And this wasn't explored at the trial as to whether or not somehow the police officer was trying to assist her with what she may have seen. None of the police officers appear to give any evidence that they met and spoke to the two women before the 26th.
This was her evidence saying that it was a police officer who did not come into court, and a police officer had been called into court, which was Mr. Hanley. It wasn't him. I cannot recall his name. It was not the one who came into the court. I spoke to him the night he came by my house to tell me what he heard, and then he told me he will come the next day to take a statement, and that was it.
Yeah.
So Miss Gray was saying there's no notes about what was said by either mother or daughter before they made their statements, but neither is there any note of what the officer told them.
Only this particular reference I have seen that, not in relation to the daughter. And if this witness says that she did see a police officer, she's likely to be telling the truth about that. We've not had a name, and I've had no further matters that come within. It's important that you've raised this, but the answer is also important. Her evidence doesn't get any better than what we get 2 days later. She really is just speaking about what she sees. And a police officer, we know, didn't see her vantage point and see what had happened. So if she recognises somebody that she calls Daddy Screw, and she's able to say about the brother and the time she's known him, whatever that police officer said to her doesn't appear to us to have altered what she was able to give in her statement of the 26th.
But presumably, this meeting took place on the 25th.
It must have done.
Yes. So when he said, I spoke to him a night, he came by my house to tell me what he heard. I think we can make a fair inference as to what that was, because by then the appellant was already in custody.
Yeah. And the way to test whether that incident, whatever it was that the police officer said, is the reliability of what actually did occur with all of the alibi witnesses. Not alibi witnesses, but ID witnesses. And that's important because one of them we will come to is giving evidence which actually fits in perfectly well with the mother and the daughter in relation to her account.
Ms. Weeks, you should be looking for a convenient break. I know it's a long thread and you don't want to cut it.
It is, but I can end this thread now. That's a feature which is important. And you may see a feature which makes one feel uncomfortable that an officer's having a chat with a witness before her statement and potentially after a man has been arrested. But we need to go back to see whether whatever was said to her makes any difference to the reliability of her account. When you see it in the round with other ID witnesses and other evidence, I can stop at that moment.
2 o'clock.